Welcome to The Explainer. Today, we are breaking down the 15 Supreme Court cases that you absolutely need to know. These aren't just old, dusty legal documents. These are the decisions that have literally shaped the country around you and protect the rights you exercise every single day.
So let's just jump right in with a question. When Congress passes a law, when the president signs an executive order, who gets the final say on whether it's actually allowed? Who's the ultimate referee? The final boss of the U.S. Constitution?
And the answer, believe it or not, comes from a case way back in 1803, Marbury versus Madison. This is the one. This is the case that gave the Supreme Court its biggest power and established it as the final word on what the Constitution means.
To make all this easy to digest, we've split these cases into 5 main parts. First up, how the court actually got its power. Then, we'll dive into your First Amendment freedoms. After that, we'll cover the landmark battles for equality and the right to vote. Then, we'll look at the rights you have if you're ever accused of a crime. And finally, we'll talk about how this whole conversation is still going on today.
All right, let's get into Section 1. You see, before the court could start defining rights for everybody else, it first had to figure out its own power. These early cases were all about setting the rules of the game between the federal government and the states.
So the big idea that comes out of Marbury v. Madison is this thing called judicial review. And you can honestly just think of it as the Supreme Court's superpower. It's the authority to look at any law from Congress, any action from the president, and say, nope, sorry, that violates the Constitution. It is the ultimate check on power. And these next 2 cases are a perfect example of the constant tug of war over government power. On one hand, you have McCulloch v. Maryland, where the court said, hey, the federal government has implied powers, things that aren't spelled out but are necessary. But then fast forward nearly 200 years to 1995, and the court goes the other way in United States v. Lopez. It basically reined in Congress, saying that regulating something like guns in local schools, well, that's a step too far for the federal government.
Okay, on to Section 2. This is where it gets personal. We're talking about your First Amendment freedoms, the right to speak your mind, to practice your religion, and to have a free press. These are the rights you probably use every single day.
Now, religious freedom has 2 sides, kind of like a coin. On one side, you've got a case like Engel v. Vitale, which protects your freedom from religion. The court said public schools can't make students pray. That's called the Establishment Clause. But on the other side of the coin is Wisconsin v. Yoder, which protects your freedom to practice your religion. This case said Amish families could pull their kids from public school for religious reasons, and that's called the Free Exercise Clause.
So big question is your speech always free? Well, not exactly. The case Schenck v. United States gave us the famous clear and present danger test. You know, you can't falsely shout fire in a crowded theater. But what about at school? Well, Tinker v. Des Moines made it clear that students don't leave their rights at the schoolhouse gate. And then there's the huge case for the press, New York Times v. U.S., which said the government almost never gets to stop a story from being published. That's a principle called no prior restraint.
All right, Section 3. We're now getting into some of the most powerful and, frankly, most important cases in the history of the country. We're talking about the long, hard fight against racial segregation and for the fundamental right to vote.
I mean, just look at this timeline. It really shows you what a long journey this has been. For nearly 60 years, the shameful idea of separate but equal, from Plessy v. Ferguson, was the law of the land. It took until 1954 for Brown v. Board of Education to finally declare that separate is never equal. And just a few years after that, Baker v. Carr would change the game for voting itself.
The power of the Brown versus Board decision really comes down to this one simple, morally clear statement. The court said, unanimously, that separating children just based on their race creates a feeling of inferiority that is fundamentally unconstitutional. I mean, this one sentence sent shockwaves through American society.
So, the fight for equality then moved to the voting booth. Baker v. Carr established the simple but revolutionary idea of one person, one vote. It means your vote should count the same no matter where you live. Then later, in Shaw v. Reno, the court tackled the really complex issue of gerrymandering, saying that even if you have good intentions, you can't make race the only factor when you draw voting districts.
Okay, let's move on to Section 4. What happens if you find yourself on the wrong side of the law? Well, your rights don't just disappear. In fact, a handful of incredibly important Supreme Court cases have spelled out exactly how you're protected.
You can think of these cases as a sequence of shields that protect you. Step 1, the search. Thanks to Mapp v. Ohio, police can't use evidence against you if they got it from an illegal search. Step 2, the arrest.
Miranda v. Arizona is why you hear officers say you have the right to remain silent. They have to tell you your rights. And step 3, the trial. Gideon v. Weinreich is a huge one. It guarantees you a lawyer, even if you can't afford one, ensuring justice isn't just for the wealthy.
And this whole idea of applying the Bill of Rights to the states is a really big deal. A more recent example is the 2010 case McDonald v. Chicago. This is the case that said the Second Amendment right to bear arms isn't just a rule for the federal government. It applies to state and local governments too. And that had a massive impact on gun laws all across the country.
So that brings us to our final section. And this is such a critical point to remember. The Constitution is not some fixed document that's locked in a museum case. It's a living, breathing text. And the Supreme Court is part of a nonstop conversation about what these words actually mean for us today.
And there is no better example of this ongoing debate than Roe v. Wade. For almost 50 years, this decision protected a woman's right to an abortion, based on the right to privacy. But in 2022, the court completely changed its mind and overturned it. It's a really stark reminder that even rulings that seem set in stone can be revisited and changed by a new court.
And that conversation is happening all the time, across so many different issues. Look at these other huge rulings. Citizens United asked if money is a form of speech. The court said yes, and that totally changed how political campaigns are funded. Obergefell v. Hodges asked if there was a right to same-sex marriage. The court said yes, legalizing it across the whole country. And way back in United States v. Nixon, the court answered a huge question. Is the president above the law? The answer was a clear no.
So when you step back and look at all of this, what's the big takeaway? It's that the Supreme Court's work is never, ever done. Its decisions are a living force that shapes America every single day. The conversation is always continuing. And that leaves us with one final thought for you to ponder. What's going to be the landmark case that defines your generation?